time since being elected president in 2016, was deposed today on camera over at Trump Tower after being ordered by a court to answer questions under oath in regards to the suit, which was filed by several protesters who alleged that they were roughed up by Trump's security detail following a protest outside his Manhattan building in 2015, where the demonstrators were protesting his immigration stances. His 4.5 hours under oath today could be testimony that could be used in trial if the case goes to trial. Joining us now, NBC News investigations correspondent Tom Winter and former Deputy Assistant Attorney General and former U.S. Attorney Harry Litman. Tom Winter, you first. Tell us about this case. Will it go to trial?
Well, that's going to be a big question going forward, and I bet some of that depends on what actually happened at Trump Tower today in that nearly 4.5 hours worth of testimony that you just referenced, Nicole. I think when you look at this and look at this case, there is video of this alleged assault that occurred. There are images of this alleged assault that occurred. That was an important day in the Trump candidacy. It may feel like 2 weeks ago or 20 years ago, but it was just a little over 7 years ago that Trump pledged his allegiance to the GOP and said he would not run as a third-party candidate, September 3rd, 2015. And that's when this protest and alleged assault took place. There are allegations that a protester was hit in the head, was punched by Keith Schiller, Trump's former personal bodyguard and right-hand man, that their protest signs were destroyed and that another protester was nearly choked. So significant allegations of assault. And what we'll have to see going forward, Nicole, I think, as we watch this case is whether or not there's any talks of a settlement and whether or not the attorneys for the people that have alleged these assaults are able to prove that Trump knew that these bodyguards were under his direction and that according to law, and there's a theory in law, and Harry is probably much better equipped to talk about this, but a theory of law that essentially if somebody commits an act, an intentional act that they were authorized to do on your behalf as an employer, that you may be personally liable. So I think that's going to be another key turning point in this case.
I wonder, Harry, this is something I've asked you about. I want to show you now. Trump did advocate violence. Let me show you from our friends at Rachel Maddow.
If you see somebody getting ready to throw a tomato, knock the crap out of them, would you? Seriously. Okay? Just knock the hell. I promise you, I will pay for the legal fees. I promise. I love the old days. You know what they used to do to guys like that when they were in a place like this? They'd be carried out on a stretcher, folks. Get out of here. Get out. Out. Oh, this is amazing. So much fun. I love it. I love it. We having a good time? USA. USA. All right, yeah, get him out. Try not to hurt him. If you do, I'll defend you in court. Don't worry about it.
Harry, Trump calling for violence against protesters, promising to pay the bills if anyone gets sued for carrying out violence against protesters, and Trump romanticizing an era where violence against protesters that's so severe you're carried out on a stretcher is the norm.
Sure sounds like the portrait of someone who's authorized his bodyguards to use violence. That's what the plaintiffs say. And very significantly, Keith Schiller, the actual goon who we have on videotape, said that he was authorized to use violence. Very significantly, Nicole, the judge let those snippets be played today. So the defense attorney told us he was able to question Trump on these campaign rally statements. I think a lot of judges wouldn't have permitted it, would have said it's too far afield. This judge did, and going to what Tom said, I do think it makes settlement more likely because we are now, everybody, going to see this deposition. It's designed to be played at trial if there's a trial. And the only way to keep it from now being made public is if he settles the case at a pretty penny, I would think, because the plaintiffs now know they have some sort of leverage over him.